Well, we're going to call this meeting to order again. The Banking and Consumer Affairs Subcommittee, we're now in session. Where is our clerk? There he is. Mr. Clerk, will you take a roll call?
Mr. Chairman, you have 7 members present. You have a quorum.
Thank you, Mr. Clerk. A little bit of house cleaning here before we get started. Off notice is on the agenda is number 5, House Bill 0719. Also off notice is number 7, House Bill 532. And with that, we're going to break stride here just a little bit. And Chairman Bricken, could you discuss your bill? Do we have a motion to second?
Motion.
Second.
Thank you for allowing me to ahead and get this out of the way. This bill has an amendment,
Excuse me, Mr. Chairman, do you have a amendment with
Yes.
this?
4585.
Motion on the amendment.
The amendment is on the bill. Mr. Bricken, or
And-
Chairman Bricken, please explain your bill.
All right, the amendment makes a bill. This is, adds a consumer protection violation to our statutes that says someone cannot call someone and claim they're involved in a lawsuit and then basically try to extort money from that person. So it makes it a consumer protection violation. So that is what this does.
Thank you, Mr. Chairman. Any discussion on the bill? Mr. Clerk, please open up the voter. All those in favor of House Bill 922, vote yes. All those opposed, vote no.
Mr. Chairman, you have 6 ayes and 0 noes.
House Bill 22 will go on to commerce.
Thank you. Thank you.
I'm
Committee.
sorry, 922. I'm sorry.
Okay.
We're going to start right back up here at the top. Number 1 here. Later, Garrett. And later, you got an amendment traveling with this?
I do, Mr. Chairman. It is amendment coded 6000.
That's what I've got. We got a motion second on the amendment.
And the amendment makes the bill, Mr. Chairman.
Yes, sir. Mr. Leader, please discuss your bill.
I certainly will. Thank you, Mr. Chairman and committee. Committee, I don't know if you were on this committee when you all passed the Tennessee Information Protection Act. It was a Data Privacy Act. It was very extensive. Took me a while to get that passed. I'm literally changing, I think, 2 words in that bill where it says organized under the laws of this state. That's going to state organized or regulated under the laws of this state, and it deals with public utilities. Mr. Chairman, that's the bill.
Thank you, Mr. Leader. Any discussion on the bill? All right, we're ready to vote. Mr. Clerk, please open up our voting booth.
Mr. Chairman, you have 7 ayes and 0 noes.
Thank you, Mr. Clerk. House Bill 911 will go on to commerce.
Thank you, Mr. Chairman and committee.
We're going to roll House Bill 0145. We're going to roll it to the hill and be ready for House Bill 0772 by Chairman Powers. Motion second. No amendments, Mr. Chairman. Please discuss your bill.
Thank you, Mr. Chairman. And as you know, I've chaired this for the last 3 General Assemblies, this particular committee, and we never had this much excitement when I was on. I appreciate being here today, and thank you all. House Bill 772 updates the current law to address payments on insurance premium finance loans by electronic means and allow Tennessee insurers to expedite payment of loan installments by the preferred payment method. Insurance premium financing is currently regulated by Tennessee Department of Financial Services and subject to the statutory provisions of the Premium Finance Company Act of 1980. And House Bill 772 replicates the provisions from the Industrial Loan and Thrift Company Act related to payment of loan installments by credit card and other electronic means and collection of insufficient funds or handling charge per payment. And with that, Mr. Chairman, I renew my motion. Be glad to take any questions.
Thank you, Mr. Chairman. Any discussion on the bill? Chairman Hale.
Just want to make sure what we're doing is they're able to charge this fee, just like I do with my business. I have a sign, they're able to pay for cash, check, or whatever, but this just covers the expense that these companies are charged by processing a credit card. Is that right?
Mr. Chairman.
Yes, sir, Chairman.
Yes, that's right. If they, yeah, they can pay the others, there's no convenience fee, only if they use that card and only what that fee is, no more than that particular fee,
Great
just to
bill.
get their money back.
Thank you so much. Thank you, Chairman.
Yes, sir. Any other discussion? Yes, sir. Mr. Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes have it. House Bill 772 will go on to commerce.
Thank you, Mr. Chairman, committee.
And with that, before we start our next one, I've got to run and present 3 bills. So y'all will be in much better hands with the rock star Chairman Vaughn there. So I will return, I hope. Godspeed, Chairman.
All right. Next, we've got House Bill 1011 by Representative Fritz. Motion. Second, you've got a motion and a second. Representative Fritz, why don't you tell us about House Bill 1011? Let me check. Do you have any amendments on that? None. Okay.
Thank you, Mr. Chairman and committee. House Bill 1011 is a piece of legislation seeking to protect small business owners and consumers in Tennessee. Some of y'all heard this last year. According to the U.S. Bureau of Labor and Statistics, there are more than 600,000 small businesses in Tennessee. 470,330 of those are so-called non-employer firms. These are entities like sole proprietorships and partnerships where the owners of the business do all the work. One of those type companies is why I bring this to you today. There are also more than 142,000 businesses that employ fewer than 100 people in Tennessee. This bill seeks to be a freedom bill. We certainly need online payment processing in the state of Tennessee and in these United States. It's great for our economy. It's an important thing for us to have. And I and the persons on behalf of this, I bring this bill on behalf of, support that as well. Online payment processing systems are holding or freezing funds of those businesses who do not fall in line with their political or social agendas. This is usually done without any warning or without the business owner knowing or understanding the reasons and the actions. Many, if not most of these small businesses do not have the cash flow to withstand the delay in that money coming into their business. By interrupting the positive cash flow, these woke globalist entities are able to drive these companies out of business. One of the examples, the one that I will offer you all that sparked this bill for me was Your American Flag store in Harriman, Tennessee. And at one point in time, PayPal was holding $110,000 of their money. And they did that with no notification to the business owner or to all those customers. So they not only were starving out this small business, but they're also ruining his reputation because people had cut that order for that flag, for that wooden flag, and they had not received it and hadn't heard anything back. The owner of this company finds this out with the way PayPal and all the online payment processing systems. And again, I'll say this so you'll fully understand. So we've worked with lots of lobbyists, and I'll be just candid with y'all, Chairman. I'll never satisfy them all. We had 3 K Street lobbyists come down last year to oppose this bill. And I honest God had them sit in my office, and the vice president of PayPal said to me, well, you can trust us to hold your money because we only hire retired FBI and CIA agents, so you can trust us when it's okay to hold your money. He looked me square in the eye and said that. And I thought, you really don't understand how this is supposed to work. In Roane County, if I were to ask my friend to go buy some groceries for me and gave them $20, and they just kept my $20, we'd call them a thief. So these folks hold the money. They almost put this business out. What this bill very basically seeks to do is to make sure that the companies, the users, which is defined in this bill, clearly defines what a user is. It defines the user as both the purchaser and the seller to make notification. It also, this bill covers that if there is something nefarious taking place with the business to protect the banking laws and institutions, these online payment processing, that it doesn't get them sideways with federal law. And we've done our very best to accommodate that. So with that, I'll stop and ask for your favorable support on this bill.
Thank you. Thank you, Mr. Sponsor. Speaker Marsh, you got a question?
Thank you, Mr. Chairman. And Representative Fritz, has this happened to more than one company that you know of, or is this the only one that you've been told about?
Mr. Sponsor.
Thank you, Mr. Speaker. And it has happened to several. I have listed several here. A settlement was reached with PayPal after PayPal had frozen the account for over a year. This is according to WATE. It's a Knoxville TV station. Don Dare in December of 21. And the quote that we took out of that specific example was, and then the message came through that they were going to hold my funds for 180 days. Said Small. Mr. Small was the owner of the business, or Mrs. Small was the owner of the business. She had no access to her money when her baby was about to be born. As a result, the bills were mounting. To make ends meet, she had to take out a title loan with high interest rates. Second example, PayPal Holdings Incorporated violated racketeering by freezing customer accounts, according to a lawsuit filed by 3 claimants in 2022. PayPal reportedly froze the assets for Moms for Liberty. Governor DeSantis vowed to fight that. That was in July of 2022. I can give you more examples if you like, but it was more than one. It hit me personally with the company in Roane County.
Speaker.
Well, how would they notify these people in your bill to let them know that they're freezing their account?
Mr. Sponsor.
Thank you, Mr. Speaker. And it just requires even an email notification to make sure that the users have been alerted to the fact that the funds have been frozen. It says just in Section B, except as provided in Section C, an operator of an online payment system shall not freeze the funds of a user without first providing the affected user with written notice of the online payment system's intent to freeze the user's funds. So we tried to not make it onerous on the companies, just to make it something that wouldn't cost them money, because we do need these companies. Many of our mom and pop businesses around the country and around our state today, they rely on PayPal and Venmo to be able to make sure that they've got a mechanism to sell their products into the world. So we're not at all trying to make it onerous on them. We just want them to not take it upon themselves that it's okay to just hold your money, but to make a notification of it. And it goes on in the bill to say that they've got 30 days. If they have some reasoning, some legal reasoning to actually hold it, it gives them 30 days to make that notice. In the case of my constituent back in Roane County, it was months. Mr. Stocky had come up and testified last year. They started feeding the money back to him after he complained enough, never really answered his questions. And then finally, the last $10,000, as I recall the story, the last $10,000 that they had held of his, they were going to ask him to sign a non-disclosure agreement before they'd remit those final funds to him. And Mr. Stocky in this case just said, "I'll tell you what, you can keep the $10,000. I'm going to tell people about this."
Yes, sir. Speaker Marsh.
Did they give him any reason up front or any time during this whole process of why they were holding his money?
Mr. Sponsor.
Thank you, Mr. Speaker, and thank you for that question. None that satisfied any answer. His suspicions are these, Representative Marsh. He started modifying the flags that he was selling to have Trump or Trump images on like a wooden type flag or a Christian cross. And the holding, according to Mr. Stocky in his case, started to take place after his merchandise bore those two symbols. And he really feels like he was targeted for his religious and political beliefs by these companies.
All right, thank you.
Yes, sir.
But if you would indulge me, Representative Lynn. Okay, so we're familiar with this.
Yes, sir.
Could you help me understand how the notification of someone, if they're doing this because of suspected fraudulent activity, does the 30-day or whatever notification period you have, could you explain to me how you've covered that this year? Because what you don't want to do is say, if they think they're defrauding people and there's suspicious activity in this account and they say, well, we've got to notify somebody before we save people's money. Tell me how all that works in your bill, or how you foresee that happening.
Yes, sir, Mr. Chairman. Thank you for that good question. And as you know, the iterations of this bill last year, we had some concerns from our banking folks here in Tennessee. And so we made sure that we, in amendments to that, excluded the banking organizations in the state. And we made sure that we didn't do anything that was going to be deleterious to what our banking institutions do to help what are often seniors who are victimized by scams and so forth. And if you look in the bill under B and C, and it covers the 30 days that you mentioned, Mr. Chairman, it said must be limited under C or otherwise provided in a manner that complies with 31 Code Federal Regulations 1022.320 and 31 U.S. Code 5318. So we put that in specifically so that we didn't get these companies that are playing honest business with the users sideways with federal law.
Gotcha. All right. Thank you. Representative Lynn, I apologize for jumping in line in front of you.
Do I hit something? Thank you, Mr. Chairman. Representative Fritz, I remember this bill from last year, and I remember the witnesses coming to testify to us, and I'm happy that you've brought it back this year. The notice that the online payments system must provide, do they give reason? I mean, does the person whose money is going to be held, don't they get to know a reason? Don't they get a chance to defend themselves? It seems that just notice we're going to hold your funds is very vague. And I do remember your bill last year. I think it did that. But also there should be notice of an appeal process. You know, let me appeal this. Let me defend myself. All of that. Is that included?
Mr. Sponsor.
Thank you, Mr. Chairman. Thank you for that great question. I appreciate it. On behalf of my constituent and what we adjusted to in this, because as you recall, we're asking for much more last year, what I thought was much more. But we reached what we thought was a happy compromise to try. And again, I will never satisfy those lobbyists, if I can say that on the record. But we tried to reach a compromise. My constituent in this case would just like to have known before he went back, because I didn't learn until I started this bill that if I am the producer of some product and I'm going to sell that product to the market, and Representative Hemmer may be that the purchaser of that commodity, and this person is the online payment processor, that when Representative Hemmer would put in an order, I would get a notification electronically to make one of those flags. And he would pay, and that money would be deposited in an account with the online payment processor. Well, then that becomes money that I withdraw from the online payment processor to buy supplies to be able to continue whatever it is I'm making. And my constituent in that case, just weeks and then months into the process without notification, couldn't withdraw because the money had been held. He knew he had orders that had come in, but he wasn't able to withdraw money from that account with, in that case, it was PayPal, to be able to buy those supplies. So it put him in great financial risk there. And I think the longer term damage in his case was more than the monetary part. It was that the person I offered as an example, Representative Hemmer, thought that he had ordered something from me and I had just failed to supply it. So there's great reputational damage in the way we're doing this. So we satisfied ourselves with just make a written notification. If that's an email that we're holding the funds, at least that we know, and at least then that user who's the producer side can reach out to those folks and have orders in and be able to say to them, hey, we've had this issue and we're working on it.
Mr. Chairman, just a follow-up.
Yes, please.
It seems, if there's a violation of law and there's a court order to hold the funds, certainly that is, something a company should respect and do. But as I understand it and remember, these companies just arbitrarily on their own said, we're not giving this money out with no inquiry from a DA, a court, or anything like that. They just decided on their own, we're not giving this money out. Isn't that what I recall from last year?
Mr. Sponsor.
Thank you, Mr. Chairman. Yes, yes, ma'am. That is what happened in this particular case. And what was suggested by some of the other examples when we began to research this, that there was, it was just a holding of the funds. And certainly, again, the reason that we have the U.S. code listed here is we don't want to get that company doing legitimate and good business and honest business with these users to find themselves crossways with the federal law, because there are requirements that they have to follow to make sure if there's something suspicious that they freeze funds. And that's why we put in the 30 days after that. So it's prior to, if it's not that, and 30 days if it gets into that area.
Representative Hale.
Thank you, Representative Fritz. So when we look at laws we pass and legislation we look at, one of the things that I struggle with that's been mentioned, and I remember the testimony last year, and I'll hit maybe something else on that in a moment, but we can't assume that it's political targeting. We need to know, and if that's the case, then we come up with a law that specifically addresses that. So, I mean, I struggle with that part of the proof of it being political targeting. If I remember right from the testimony last year, it was like orders were coming in and they were not getting them produced. So obviously there had to be some complaint that people weren't getting their stuff in a timely manner. So then that raises a red flag that, hey, are this man getting all this money and not producing? I see freezes in a lot of situations. I mean, a lot of times freezes are normal. I see them in insurance checks. I see them for out of town things when we get and stuff being in business. So I guess I come to this, and you mentioned some previous cases or settlements and stuff. I feel like that we're very broad, but we've got basically one company that we see that has maybe done this numerous times. So it's like we're punishing others for maybe for some actions of PayPal. So, and I knew I kind of threw out several things there, but hit them all at one time, and then you can kind of give us some response.
All right, Mr. Sponsor.
Thank you. Thank you, Mr. Chairman, and thank you, Representative Hale, for the questions. I can give other examples of other companies that we have here as well. And it was there is a penalty under the code that we're offering, the bill that we're offering, and in violation of the section by an online payment processor. Our system constitutes an unfair, deceptive act under 4718-104, and it's punishable as provided in that part. I think that's a bar. Innocent until proven guilty. We all adhere and hold and cherish to that. My big objective with this is to just not have another business in Tennessee that has their dollars held and they have suffered reputationally and financially as a result of it. Just let them know that they're going to hold the money for whatever reason. Give them a notification. If it's something that gets into the U.S. code part, then give them notification within that 30 days.
Representative Hemmer, you have a question?
Thank you, Mr. Chair. Thank you, sponsor. Just curious, is there any other states that allow this same notification that you have in your bill?
Mr. Sponsor.
Thank you, Mr. Chairman. I apologize, Representative Hemmer. I don't know the answer to that question. I have not researched the other states. I really took this one just on the Tennessee basis.
Representative Hemmer.
Thank you. Yeah, and I guess that's one of my worries is the bill's very broad nature and the unintended consequences of it. And, with all the fraud and the other prohibitions, I mean, these are multinational corporations and the just amount of commerce that comes from our small businesses that use these platforms. I know that's the last thing this panel wants to do is trigger something or affect some kind of terms and conditions where these companies would pull out. I hate to think the amount of money that flows through the state, Venmo and PayPal, et cetera, from our small businesses. So how should we be thinking about this in terms of, or what work have you put into this bill to make sure there is no unintended consequences of these companies? I mean, obviously they came to you last year and said that they didn't like it. Is it still in that posture, or is it a little bit different this year?
Representative Fritz.
Thank you, Mr. Sponsor. I think they're probably happier with it than when it started, and I'm putting words in their mouth, so I'm going to be careful with that. But again, I reached the point, Representative Hemmer, that I'm not going to satisfy them. They want, I'll just be candid with you. In my conversations, they want complete control of your money. They do not want to be accountable to you for your dollars. They don't care if they ruin your reputation because they know they've got this market that we have to have. And I want to protect that. I want to protect that market. In this case, Mr. Stocky should have the opportunity, if he disagrees that they're holding his money, he ought to be able to go from PayPal to Venmo or to whatever the other online payment processing system is. And that notification would allow him to move and exercise the free market. So we have tried not to do something that's going to be harmful to the industry because I fully recognize how much we need this. But I will never satisfy the lobbyist on this.
Any other questions? I have one, looking at subsection D or D of section 1. A violation of this section by an online payment system constitutes an unfair or deceptive act prohibited under yada, 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 and is punishable as provided in this part. Does this mean that we're going to expect the Attorney General to be wielding the unfair business practice in this case to seek the restitution or adjudication of this matter?
Thank you, Mr. Chairman. Yes, sir.
Okay. All right. Thank you. All right. Does anybody else have any other questions for our sponsor? We've had good questions, good conversation about it today. All righty. Well, what we're going to do now is we're going to tee this up for a vote. So all those that are in favor of sending House Bill 1011 on to Commerce, please signify by hitting the green button, or signify by hitting the blue button, or signify by hitting the red button. So all those vote. Cast your vote now. The vote open. Tally the votes. Madam Clerk, has everybody voted? Anybody want to change their vote? Who's our vote tallier? There you go, Mr. Clerk.
Mr. Chairman, you have 2 ayes and 4 noes.
All right. Mr. Sponsor, we'll keep fighting for your,
Thank you, Mr.
keep
Chairman
fighting for your
and committee.
folks. That's-
Thank y'all.
Your bill
Thank y'all.
fails.
Thank you.
Next up, is House Bill 0719 by Chairman Moon.
It's off notice, Mr.
Oh,
Chairman.
excuse me. Then we're back. Let's go 0342 then. We'll get on the right
That's all right.
line up here. 0342, and we've got some
Motion
people
is-
to testify today. Did they make it into the
Well,
building?
I think we're good. You're in good posture, Mr. Chairman.
Okay.
I do have an amendment 4247 that rewrites the bill.
All righty. Let's get that adopted before we begin our conversation. All those in favor, please signify by saying aye. Any opposed, no. The ayes have it. Your
Thank you,
amended bill,
Mr. Chairman, and I know we are under time constraints. 3:00, you're going to be in my committee. So, Mr. Chairman, 342 as amended seeks to protect Tennessee veterans who desire to contract with someone or a company to assist, advise them with their veterans disability claim. Whether we want to accept it or not, there's organizations in Tennessee right now doing this. They're here. They're unfettered. They're operating however they see fit. What this bill does specifically, as amended, addresses 7 things that are deceptive under our Consumer Protection Act if we pass this bill. We have a commitment from the Attorney General of the State of Tennessee that they will pursue these. Most of these have to do with making sure there are clear written agreements between that veteran and the person that's advising or consulting with them. So I'll be glad to go through each one of these items if you desire. But the thing to remember, if this passes, each one of those become a violation. And each day that they have it on their website or they violate is a separate violation. And under the Consumer Protection Act of the state of Tennessee, If they willfully and wantingly continue, they're subject to triple damages and a private cause of action, which can allow that veteran to go forward and sue and have the attorney's fees paid if they prevail. Again, there are organizations who are doing this now. If we stop and walk out of here right now and don't pursue consideration of this bill as amended, this will continue unabated. So I ask you to give this consideration a positive vote because it's going to protect that veteran. And I'll be glad to answer any questions on the bill. It's detailed on disclosure. It's very detailed on things that are violation.
All
Mr.
right.
Chairman.
Thank you, Mr. Sponsor. I have a few questions.
Yes,
And
please.
want to have a conversation with you about this because for the fellow committee members, I have a very active VFW and Collierville does a great job serving, particularly the Iraq-Iran theater veterans, that age, that are folks that are younger than me. And they've reached out to me several times expressing concern about this bill. Had Chairman Moon met with them and was trying to assuage some of their fears. And so to kind of tee this up is we have a big backlog of veterans, and we have a huge amount in Shelby County. We don't have enough veteran service officers in Shelby County for the number of veterans down there. We have the lowest ratio or the highest ratio in the state, something that we need to work on. That's a separate matter. But so we've got these backed up claims. And Mr. Sponsor, I want you to feel free to interrupt me if I get this wrong. We've got this backed up number of claims. There's veterans that are not receiving their benefits. So typically the people who are helping them pursue those claims are either VA or American Legion or VFW, some type of service organization, volunteers who help them process. But our existing on-ground resources do not meet the demand presently. And so is that a fair?
That's a fair statement.
Okay.
Yes, sir.
And there's no regulation of who can assist a veteran and the terms under which they help them get their benefits. Is that correct for today?
Well, possibly if they're certified by the state of Tennessee, the Department of Veteran Services, then they can help that person, but they cannot charge for that service. That's clear. What's happening, though, people get frustrated with the long delays, or they have something that they don't feel comfortable going and sitting down and discussing military sexual trauma because they may run into that person in Kroger's. But for whatever reason, they don't go, but they go online and seek some kind of help or assistance. And that's what's opening the door. As you know, there's been recently a large number of people terminated in federal government, and they will eventually be hired back. But this is going to make the issue we're addressing today even more critical because the frustration level is going to grow. It's already, the passage of the PACT Act put a lot of people seeking claims, filing claims.
And the PACT Act deals with the burn pits.
The burn pits, it also deals with all the way back to Agent Orange, which increases the presumptive. If you have it, you automatically are covered. Now it's just a condition of getting the claim filed and getting it worked through the system, which can take months, maybe years, and people go online and get and affiliate with someone, and this puts guardrails in place saying, okay, you can't charge a sign-up fee. You can't do it. It's a violation if we pass this. You must say to them, you must have a written agreement that everybody agrees, and there's disclaimers in that written agreement that whoever's advising you or consulting with you for a fee has to provide this disclaimer, that they're not part of Tennessee Department of Veteran Services. They're not affiliated with any congressionally chartered nonprofit, which is every one of your veterans organizations. DAV, VFW, American Legion, Military Order of Purple Heart. They have to clearly understand, and nor can they represent, they have a relationship, either directly or implied, that they can get you a certain benefit, a certain level. I may be 10% hearing loss. It would be, if we adopt this, that they can't get me to 40% or 50%. They can't say that specifically. If they do, that's a violation. That we think you might have sleep apnea too, because you're hearing your tinnitus or whatever. Again, we step through the thought and make sure that we put guardrails up. If we don't,
Let me get back to my
Yes.
my tale.
right.
So the PACT Act comes along and puts a lot of money into veterans benefits, long overdue. So in order to get these veterans with all of these backed up claims, I think you mentioned 100 or your witness hundreds of thousands of
Well, I don't
claims.
know if it's hundreds of thousands. It's a lot of claims, and it's going to be even worse the next 12 months because of the changes in the VA.
Oh, I was
Yeah.
thinking across the country.
Yes.
And so what we've got is we have these veterans who are now trying to do their best to access these benefits that have been funded. The infrastructure is not in place to help them get there with the backlog that's there, at least in the bill sponsor's understanding and his perception. And we all know what a stand-up guy for the veterans community he is in our Veterans Caucus. So that's what I believe what he's trying to do is establish guardrails for people as they seek these benefits on behalf of these veterans. Now then, at the same time, entrepreneurs see an opportunity whenever there's funding in place to provide a service to people for a fee. And so there's a free path. It's kind of like, I look at it as kind of like my taxes. I can go online and get the TurboTax free version, or I can pay an accountant who's probably going to do me, be able to work on a more complicated basis than I can that way. And so what we're trying to establish is that if this business is allowed right now,
They're there.
it's happening, it's just unregulated. Do we provide guardrails in place to protect these veterans from unscrupulous operators and from a situation that exists today? That's my understanding of the bill, but I also understand that from talking to the veterans in my community, they're very resistant to this idea, very hesitant, because it's different from what they've seen before. And there's something that is, from my perception of talking with it, and they've been very complimentary of the bill sponsor and his Senate counterpart, and that is that your veterans may reduce their claims by the amount of fee that they pay for the services. That's been one of the things. But the problem is that unless a fee is paid to move quicker through the line, you go without your benefits longer. And so that's an individual decision that individuals need to make.
Well,
So
that's not necessarily true in the fact that Tennessee Department of Veteran Services has new software coming online, new system, which is going to help tremendously. And we get those claims in the system before the people in the Department of Veterans Affairs in DC, but folks working remotely, which is going to go away, I think, with the change in administration. But we are going to be bogged down because a lot of these people are going to be vetted and rehired. So again, people who are consulting and advising for a fee are doing it today. I don't want to give you a name, but if you Google veterans claims assistance, you'll get lists of them. And that's why we must, to protect the veteran, put these guardrails in place. So the Attorney General, right now, if there's a problem, and the veteran discovers it, where do they turn? Where do they turn? These will be violations of the Consumer Protection Act of the state of Tennessee. The Attorney General will pursue them. We've had meeting. That's where the veteran can turn and get this solved. Again, I can step through each one of them, Mr. Chairman. Be glad to. I understand the feelings. This bill, as amended, is different than what passed the Senate. There's no discussion whatsoever. It says that the contract that the veteran and this advisor or consultant, what they put in writing is going to be based on contingents. If they get zero increase, that advisor gets zero. Now, the veteran, most veterans can read and can understand, but to get away from the conflict involved in this legislation, the cap or what they can charge other than clearly stating it's on a contingency basis, which is set down in writing by the consultant, advisor, whatever, and that veteran. Everything else in my version of the bill as amended, deals with possible violations if we pass this that will rein in or regulate these people or organizations who want to advise or consult for a fee. Does that make sense?
That makes sense. Representative Lynn, I can see that inquisitive look on your face. You need to ask a question.
Thank you, Mr. Chairman. I have a question. This is kind of making me think of people who advertise that they'll help you get Social Security. There's attorneys who advertise they'll help you go through the process because it is long and difficult process. But are you saying, because I'm reading two different things, I think, are you saying that nobody could help a veteran for a fee? And if that's the case, wouldn't this entire industry go away and then they wouldn't have any help? Or could they still have a friend help?
Well, there's a loosely written federal CFR, federal regulation that says you can't do it. You can't do it. But there's a company that advertises over 24,000 veterans claims they process. There hasn't been one U.S. attorney filed a complaint. 24,000 claims that they've done. So it's kind of like someone, I think we had somebody told maybe Russia, don't. So that's what this is, putting it in the hands of the Attorney General of the state of Tennessee under our Consumer Protection Act. And it's putting teeth into that. So if they consult or advise a veteran in the state of Tennessee and they violate what's set forth in this legislation, they're going to be held accountable. Does that make sense?
It does. So right now under federal law, it is illegal to charge a veteran for assistance
There's
with
a
a claim.
consolidated federal reg that says you can't do it.
Okay.
But do you know of any U.S. attorney that's gone after those 24,000?
No, gotcha. Okay. I see you.
Tennesseans need to take care of Tennessee veterans.
Chairman Hale, excuse me.
I'll take being Chairman Hale. So, and I know you've got committee in a minute, so you may have to forgive me for being late for your
You've got two
committee.
bills
So
in front of me,
that's
too.
right.
That's all right.
Couple of questions. First of all, does this also affect veterans like survivors and spouses? Because I have seen with what I do every day, I've seen veterans come in my office and talk about being took advantage of, but then I also see after the death, spouses and stuff where they're trying to get benefits. And then they reach out to somebody that's going to get them thousands of dollars and their income's just going to be unbelievable. And I've heard all kinds of stories. So does this address that too?
Mr. Chairman.
Yes, sir.
It does. When I was driving back to district, I was having a conversation with Brian Walker from Collierville. He has a full-time job in Kansas City with the Veterans Foreign War. He brought up a name of an organization. I asked my wife, I was driving, Google that. She did. The next day, her cell phone rang. And they wanted to know if she was a spouse of a veteran, did she need help on a survivor's claim? She wanted to know, how did you get my cell phone number? Exactly what you're talking about.
Yeah.
So yes, this would apply to any VA claim. Is that correct? No? Okay. I'm sorry, I misspoke then. But if we don't put these guardrails in, then we're gonna continue to have issues come up.
Okay.
And I apologize. Misspoke.
Any more discussion on the bill? We ready to take a vote? Oh, hey, I'm sorry, Chairman Keesling.
That's okay. Thank you, Chairman. Chairman Moon, I haven't been reached by anyone in my district on this, and I find it a little strange that I'm looking over to Chairman Vaughn, and I thought I understood you to say you've got the majority of your folks down there that may not be necessarily in favor of this or not. I don't know what to do here. Who may I?
We have a speaker here.
Okay,
But,
I was just wondering, Chairman, if
Let's go out of session, Mr. Chairman.
but with your permission, I mean,
Sure.
Yeah,
Could we-
the will of the committee. We'll go out of session here. And please come up to the podium there and introduce yourself and give us your title.
Hello. Hi. Sorry about that. And thank you, Chairman, for allowing me to speak. Peter O'Rourke, I'm the president of the National Association for Veteran Rights and the former acting secretary of the Department of Veterans Affairs under President Trump. So this is an issue that is very close. I've actually worked on service-connected disability claims since around 2007. So this is something that I've dedicated a big part of my career to try to help veterans through a very complicated process. I know there's lots of questions. There was a couple things that already came up, but I think it'd be useful and maybe a little helpful to understand a little of the history of kind of how we've gotten to this point today with the service-connected disability claim process, both at the department, both with our partners, the veteran service organizations, and the individual veteran that goes through this process. We have roughly about 200,000 veterans that are made each year, and each one of them has the opportunity to go through this. In 2006, there was a change to federal law. Prior to that, the service-connected disability claim was a process done completely by the Department of Veterans Affairs. And it was, it performed pretty much as you'd expect. And so there was some issues. There was not a lot of outside assistance, accredited attorneys or agents to help them. So they changed the law to enable, to take away criminal penalties that existed and enable more assistance for veterans. One of the other things that they changed in the law was to make it very specific that the accredited agent and attorney that was going to work for a veteran, have a power of attorney and work directly with the VA needed to be accredited by the Secretary of the Department of Veterans Affairs. Makes a lot of sense because they would have access to the veterans' internal records, not just medical records that the department had, but also the Department of Defense and others, but also to ensure that the VA had some control over people that they were dealing directly with that were representing veterans. That process then led to much more assistance for veterans when it comes to attorneys and agents. But then in 2013, as expected, we had about over 600,000 case backlog at the department. And the current undersecretary for benefits then decided that something else needed to be done. Yes, sir. Sorry. I'll do this as quickly as I can. Anyway, they opened up a fully developed claims process, which basically gave a veteran their opportunity to do their claim themselves. And that started a process which got to today, which then opened the door for both veteran service organizations to help them, but also for the free market to also provide options. And so we're here today to try to figure out how do we regulate this for veterans so that they can be protected. So
Thank you,
that's a
Mr.
summary.
O'Rourke. Yes,
I'm
sir.
happy to take any questions. I know there was a couple I might be able to
Yes.
provide some clarity to.
Any questions there? Chairman Hale?
So when I asked Chairman Moon about the survivors and stuff, so can you kind of,
Yeah, I can be more specific. So the federal statute, the federal regulation, this is specifically for service-connected disability claims at the department. Survivor claims, aid and attendance, GI Bill, all those kind of application process. This would not, the law does not apply to those application processes.
so this bill addresses those disabled veterans?
Yeah,
is what we're
any
doing.
veteran that would be submitting a claim for service-connected disabilities. Yes, sir.
Okay, all right. Thank you.
Representative Hemmer?
Thank you, Mr. Chair. I think it's a sad state of affairs that we even have that kind of backlog of these type of companies, really, that we're having to get third-party groups to get the benefits to the veterans that have rightly gotten it. It's kind of mind-blowing to me. But in terms of the problem we're trying to solve here with this structure, and curious from your standpoint, I mean, what are how do you differentiate between the bad actors and the good actors in this industry?
Yes, sir. So that's a great question because that has been a point of contention for over a decade. We've had bad actors in the past, even when I was at the department, that we've had to address. The case that we had specifically was a company that was guaranteeing and making happen 100% service-connected disability claims. They were faking it. They were providing medical evidence that they were getting offshore and doing it. So we had the other extreme. My frustration has been is nobody would actually define what a good actor in this space is and what a bad actor is. And so with our association, we actually defined that very specifically. A lot of those are found in this bill to differentiate, both from a veteran's perspective, for legislatures, for the federal government, for the department to be able to say, these are good things that help a veteran. These are bad things that we should protect a veteran from.
Mr. Chair, quick follow-up.
Yes, sir.
Okay, thank you, Mr. Chair. Thank you for that explanation. Are there any other states that have set any type of guardrails? I know Representative Moon talked about there hadn't been an attorney general or U.S. attorney that done any of these, complaints or resolutions. But what are other states done to try to fight these bad actors?
Yeah, so there's two fights. There's one at the federal level, as you can imagine. There's a very similar conversation going on about this issue. But at the state level, we've been supporting legislation. I know Louisiana passed a bill last year, very similar to the bill here that you're considering. And I will tell you, I just came from Indianapolis, where we had the exact same conversation with their house there. Florida just had a vote today on a very similar bill as this that it passed. Many states are getting involved in this because it obviously is good for each state to protect their veterans. So this is, I've been to about 38 states this year.
Any more discussion? Mr. O'Rourke, we appreciate your service, appreciate you being here.
Thank you.
We'll go back into session. Any more discussion on the bill? Questions been called? Mr. Clerk, please open up the vote.
There you go.
Mr. Chairman, you have 6 ayes, 0 noes, and 1 present not voting.
Thank you, Mr. Clerk. The ayes have it. House Bill 342 will go on to commerce.
Thank you, Mr. Chairman and members.
Well, we're looking here. Yeah, let's see, I think 1216. We're now ready for, on the agenda, number 15, House Bill 1216 by Representative Johnson. House Bill 1216 fails for lack of a second. got anybody else here? Kiesling. Chairman Kiesling, we'll move on to you. House Bill 0743. Chairman, you got an amendment with this?
Yeah, Chairman, I've got two amendments, and we'll
We got a
begin with
motion
amendment
second
number.
on the amendment. Second.
Okay, tracking code 4631, that amendment does make the bill. However, we do have a second amendment, but you want to vote on
Yes, sir.
that one and then.
On amendment 4631, all those in favor say aye. Aye. 4631 will be traveling with it. We got a second amendment, and your drafting code is what, Chairman?
Mr. Chairman, it's 5917, please.
Motion second on the. Motion. It's properly before us. Chairman, you want to explain that?
I will. Yes, Chairman. It is, it's sort of a cleanup amendment. I've got three bullet points real quick that I can quickly explain it. First, it removes the word material from the enforcement provision of the bill so that the department may suspend, revoke, or deny renewal of any violation of the law's rules. And then two, the second bullet point, it consolidates rulemaking authority into one section and specifies that the Uniform Administrative Procedures Act will apply. And finally, just a couple of typos that were corrected in Amendment 1, Mr. Chairman. And with that
Thank you, Mr. Chairman.
that explains that second amendment. Yes,
All
sir.
those in favor of adding amendment 5917, say aye. Aye. Chairman, you're properly before us.
All right, thank you very much. And this is dealing with debt resolution. I want to begin by just thanking both the Department of Commerce and Insurance as well as Department of Financial Institutions for their assistance as we moved through this. This isn't anything new. We talked about it, worked on it a couple of years ago. But anyway, House Bill 743, now be as quick as I can. It modernizes the licensure and regulation of debt resolution providers. Now, let's don't get confused. This is regarding debt resolution, not credit counselors. So the bill will assist our consumers with greater transparency regarding the debt resolution. The little background to it, it goes back to 2008. We were one of the first states to adopt regulation and licensure of what was known at the time as debt settlement companies, along with credit counselors. Now, most importantly, and this is very important, debt resolution companies are barred from assessing their customers any fee until, and there's 3 points here, until one, the first, a resolution on an account has been reached for a consumer with their creditor. Two, the consumer has accepted the resolution. And then finally, three, consumer has made a payment to the creditor toward the resolution. This makes debt resolution one of the only products in our financial marketplace whose providers must deliver the benefit of their services to their customers before they are legally permitted to collect a fee. The bill will bring Tennessee more in line with the majority of states and provide improved administration and clarity for consumers. The current law, and this is very important. The current law combines regulation of debt resolution companies with credit counselors, which has proved to be somewhat difficult. The bill separates the two industries into separate regulatory regimes. It will remove ambiguities and make it easier for regulators to administer oversights. And we could go on, and I know where time is of the essence, Mr. Chairman, but I do have. Of course, she isn't here with us today, but she's standing outside in the hall. If we needed any further questions, we do have Ms. Gentry that could assist me in answering any questions. But anyway, that's it. I'll stop there and entertain any questions that maybe I could possibly answer on this.
Thank you, Mr. Chairman. Any discussion on the bill? Question's been called. Mr. Clerk, please take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes have it. House Bill 743 will go on to commerce.
Thank you, Mr. Chairman and members.
Yep. Yes, sir. Chairman Vaughn. Okay. Ms. Alexander, will you please come to the podium here?
Thank you, guys. I've been watching committees, so apologize. I just had to run when I realized you're ready for me.
Hey, we're ready to
It's been
hear.
one of those days,
I
guys.
understand. We're ready to consider House Bill 1034. Do I hear a motion? Second?
Let me find it here, guys. That's not it.
Rep, you don't have an amendment with this, do
I've
you?
got it. No, I do not.
All right.
Basically, I just want to tell you about the bill, okay? And then why I wanted to run this. I have a gentleman, a friend who lives in my community who worked for a medical supply division. He was in sales. When he joined the firm, he signed a non-compete clause for 2 years. He had been with them probably, 15, 20 years, guys. He's in his late 50s. He they called him in one day, gave him a letter and said, no fault of your own. You've done nothing wrong. We just want to reorganize and we no longer need your services. The problem was they gave him a year's severance with signing that he would not sue, but they wouldn't let him out of his 2-year non-compete. So you get a year's severance and then you're without income for 1 year. So and nobody wants to hire you if they've got to buy out your non-compete. So I just think that this is an area that we need to work on with non-competes. And I know there is some real need for non-competes in areas where there's high technical stuff and that we need that for. There's also an area in some of the things, but for sales, I don't think so. But I've spoken with Chairman Vaughn and Chairman Darby, and I've spoken with many people that have interest in this bill. And so I think we're going to come together and try to actually sit down around the table and let's figure out how's the best way we can manage non-competes in this state. So if it's okay.
3:30.
So if it's okay with the committee, I would like to roll this to next year's calendar.
Thank you, sponsor, and that's a proper motion. We'll roll it to next year's calendar. Yes.
Mr. Chairman, could you define which?
The second
Second calendar.
calendar. Okay. Well,
Yep.
thank you.
Thank you, sponsor. And please, I've talked to a lot of folks here about this bill this summer. Let's have a round table and see if we can come to an agreement there.
I agree.
Yep. Thank you.
Thank you. Oh, okay.
Yep. Did y'all tell Tammy? Did you tell Tammy this? No. Okay. Y'all gotta go. Yeah. We're gonna have to adjourn. Yep. Yep, I do too. We will. And let me tell you what we got going on here, just for y'all are not out there and, yeah. We got held up a little bit and everybody's got bills that they got to present. So we're going to adjourn and, do I need to repeat all the bills there that's going to roll till next week?
I'll give you a motion for that because everybody's going to see ya.
These are
Next week.
Yep.
Same bat time, same bat
House
time.
Bill 145 will roll till next week. House Bill 1379 will be rolled 1 week. House Bill 420 will be rolled 1 week. House Bill 316 will be rolled 1 week. House Bill 1132 will be rolled 1 week. House Bill 791 will be rolled 1 week. And House Bill 1399 will also be rolled 1 week. We are adjourned.